It's very thrilling and exciting that we had the chance to organize such an outstanding event, thanks to the participation of top-notch professionals on the international sanction field. Let's give a context to the interesting times we are living in response to what Russia has called a special military operation in Ukraine, and following a series of unsuccessful negotiations, the US and the EU, among other Western countries, as we can mention, UK, Canada, and Australia as well, have imposed, like never before in terms of magnitude and pace, a series of sanctions, most of them jointly coordinated between these countries against Russia. Western states were already in a complicated and far-reaching set of relationship with Russia as a target for, among other things, the annexation of Crimea, issues with eastern Ukraine, tampering with democratic election processes, and cyber attacks. However, further sanctions have been implemented and constantly increased in the last weeks in light of the Russian escalation of its military aggression against Ukraine. Companies, due to this intricate scenario, are navigating within a complex web of rules and regulation, trying to ensure compliance with the current sanction and trade embargoes. It's up to law firms such as ours to provide some guidance to navigate and cope with this unedited landscape. And within the effort that us as professionals are giving to our clients, we decided to organize this event. And I now thank and leave the floor to the outstanding professional that decided to join us today, starting from Paola De Martini, Chief Legal Officer of Octo Telematics. Thanks, Paola.
Thank you.
Jessica Martini, Global Trade Sanction Compliance Attorney, former America's Sanction Head of UBS, among other leading financial institutions. Thanks, Jessica. Sophie Cocard, General Manager, Sanctions, AB&C at Commonwealth Bank, and Alessandro Guaiana, Sanction Compliance Officer at European Investment Bank. I now then leave the floor to Professor Andrea Gemma for his host speech, and I thank once again the panelists of today's webinar and all the audience that is attending the event.
Grazie Emanuele. Again, thank you for having such outstanding panelists that I will maybe introduce later on. And I will switch now to Italian because we have decided that basically everybody is free to speak the language that he feels more familiar. Large part of the audience speaks Italian and English, and I'm happy also to introduce and salute in Italian our guest. Il seminario di oggi è un seminario per noi estremamente importante. Sono molto onorato di avere dei panelist di assoluto rilievo e soprattutto dei panelist che stanno gestendo in prima persona, con le mani in pasta, come si suol dire, le complessità connesse e derivanti dalle sanzioni. Vorrei condividere con voi due riflessioni introduttive. La prima è che le sanzioni, così come sono state stabilite sostanzialmente dagli Stati Uniti, dall'Europa e dagli UK, rimettono in gioco il tema di un'applicazione globale del diritto oltre i confini territoriali degli Stati che decidono le sanzioni e comportano la necessità da parte degli operatori multinazionali, dalle aziende globali, di rimisurare le proprie regole di compliance, la propria operatività e soprattutto le ricadute sul business e su aree di mercato che sono colpite dalle sanzioni. In secondo luogo, questa tematica, che è forse anche una tematica classica della worldwide range of application di taluni sistemi e taluni ordinamenti. Gli Stati Uniti certamente sono l'esempio più noto, ma adesso sulla stessa linea si è declinata UK e lo ha fatto in precedenza ad esempio con tutti quanti i pacchetti di norme relative alla lotta contro la corruzione in applicazione di quelle che erano le direttive dell'OCSE o in altre ipotesi specifiche nella lotta al terrorismo e al finanziamento del terrorismo. Oggi ci troviamo però in un quadro assolutamente inedito, perché la magnitudine e il calibro delle sanzioni non è stato mai in precedenza di questa portata, di questa invasività e di questa globalità. Evidentemente il sistema che vuole sostanzialmente scoraggiare o rendere insopportabile dal punto di vista economico il peso di una situazione di crisi a carico dello Stato, che si assume essere in qualche modo lo Stato che ha innescato una violazione del diritto internazionale, è un peso che viene però tuttavia sopportato anche da tutto il sistema economico, che con quello Stato o con quelle società multinazionali di quello Stato, o addirittura nel caso della Russia con gli singoli individui, cioè con i famosi oligarchi che vengono destinatari delle sanzioni, è un peso che ha una ricaduta generale e globale sul sistema economico, su quello che viene chiamato international trade, ma anche sulla capacità di posizionamento da un punto di vista geopolitico dei sistemi delle multinazionali, che debbono in velocità attrezzarsi per mitigare le perdite, per gestire il proprio business in maniera compliant, soprattutto quando parliamo di un business che inevitabilmente si svolge in tutte le parti del mondo con una valuta che è il dollaro, ma anche per quanto riguarda il pound e l'euro, e con tutte le necessarie complessità e ricadute operative. Avete visto che addirittura molte delle multinazionali americane hanno addirittura sospeso o cessato la propria operatività in Russia o con controparti russe, anche se queste controparti non sono sanzionate. E questo comporta proprio il problema con cui apriamo oggi il dibattito con Paola De Martini, perché Paola De Martini è il General Counsel, diciamo in Italia probabilmente il General Counsel per definizione, o comunque uno dei General Counsel con maggiore esperienza internazionale. Paola ha fatto Coca-Cola, ha fatto Luxottica, adesso è in Octo, e ha una lunghissima carriera che deriva da una sua prima fase di esercizio della professione forense con lo studio del professor Ukmar, e poi in conseguenza si è unita invece ad esperienze più internazionali all'interno di major multinational italiane e straniere. L'esperienza di Paola in questo caso è particolarmente interessante perché si trova a dover gestire un gruppo internazionale come Octo Telematics, leader mondiale nella attività, diciamo, dell'insurtech, vale a dire nella fornitura di servizi telematici a presidio a favore di compagnie assicurative per quanto riguarda l'assicurazione degli autoveicoli delle flotte aziendali nel mondo. Si tratta di un'azienda che ha una importantissima piattaforma tecnologica a cui sono collegati milioni di clienti ed è il primo operatore assoluto in termini mondiali di questo sistema. Octo Telematics opera in Italia, opera negli Stati Uniti, opera in altri paesi del mondo e sta fronteggiando con una situazione di costante stato di allerta e di allarme. Ci dirà Paola quanti consigli di amministrazione, quante riunioni, quante legal counseling hanno dovuto ricevere in questi recenti momenti per fronteggiare un tema che appare sostanzialmente più teoretico che pratico, ma che in realtà si scontra con l'operatività dell'azienda, perché loro, avendo un azionista che è stato oggetto di sanzioni, eppure essendo questo azionista non il soggetto che esercita il controllo sulla società, ha nonostante innescato tutta una serie di conseguenze assolutamente complesse e di aggravamento del business, che sta cercando in questo momento di reagire mitigando l'impatto economico, finanziario ed operativo su di un'attività complessa multinazionale con controparti che hanno accerchiato di domande, di richieste, di interrogativi e di interlocuzioni una società che allo Stato non è direttamente sanzionata né dall'OFAC né dagli uffici UK né tantomeno dalle sanzioni europee come le conosciamo pubblicate sulla Gazzetta Ufficiale dell'Unione Europea, ma che ciò nonostante vive sostanzialmente in regime di sanzioni. Lascio la parola a Paola ringraziandola di essere non solo intervenuta ma di essersi recata qui presso il nostro ufficio di Roma per parlare personalmente. Abbiamo molto da imparare, la sua esperienza è vasta, la ringrazio e le cedo la parola.
Thanks a lot, Andrea. Thanks. Well, guys, basically, my intervention is really very practical. I mean, I try to focus on what we are going through from a very, you see, a practical standpoint again, because the very issue that we are facing inside the companies is the difference between legal rules, laws application, and even advices and perception. So that's basically the issue here. So we've received several advisors from also Studio Gemma, who is supporting us a lot on this critical aspect of our, business and what we're facing. But again, even if, Andrea said something very important here. He said, and he declared immediately, Octo is not a sanctioned entity. It's not a sanctioned entity from any perspective. Not sanctioned under US, OFAC regulation, UK and EU. Nonetheless, we are struggling in giving answer every day to banks, clients, everybody around us, even advisors. Some of our advisors told us that they do not want to deal with us anymore, and we are not sanctioned at all. So again here, the very, there is something that is kind of schizophrenic because, and I understand, I get that, but again, it's the perception. So if you have a shareholder that is not controlling the company, both from a US and UK perspective, and then we will learn from our panelists the difference between, because there is a difference between, the two regulations, but they don't care, they couldn't care less, in particular for sure banks. I'm very accustomed with, banks' approach. I understand that, but they don't even tell you exactly why we want to close the relationship with you, because as you know, they will never disclose that. They're not free to disclose that. And it's really critical. So having said that, it's OFAC legislation is more, looks more into forms, while UK is much more focused on substance over form, right? So also my advice to companies in a situation that could be not far from ours, for example, when you seek an advice, explain every single detail, disclose to your lawyer every single kind of, even side agreement if you want, I'm not talking about shareholder agreements, that is obvious. That any kind of relationship or cross, relationship, if you want to call it like that, because again, focusing more on the UK legislation and EU as well, that then the government will check everything in details, will conduct interviews, even interviews. They will find maybe even some piece of paper that you did not disclose with your lawyers. So they might end up having another conclusion. So my advice to companies is to disclose everything with your own lawyer, something that we've done, of course, and we have nothing to hide. And again, even if in our case, and that's why I accepted Andrea's invite to participate today, is just to tell you, I mean, it's honestly here, the point is not how to, to apply the legislation or regulation or whatever, but the real issue here, again, is the perception, because I don't even complain, you know what, because what we are going through is so awful and dramatic, so I don't want to be, I share the feeling, but if I were, a client or a bank, I would really focus more on the status and the fact that there are companies that are not sanctioned at all, and you cannot treat these companies as, the bad guy, because that's not the case. But still, I'll stop here, and I'm at your disposal.
Yes, just one question. Paola, I forgot to say, which is key and important as well, that Paola sits in the board of Banca Montepaschi di Siena, appointed by the government. And she's experiencing as well the kind of approach that one national, which I would say nationalized bank, is taking towards these sanctions and clients that might be directly or indirectly affected from the sanction. I mean, I don't want to ask something that is covered by confidentiality. Sure. We know that you cannot disclose. We know that there is the full secrecy on the board discussion, but just to get the flavor, how does the board and the CEO of the bank approach this issue? What are the concerns?
Well, you see, I've got two hats here.
Yes.
I've got two hats. So, banks are exploring in depth the issue, and honestly, so far, I would say we're not ready, maybe to disclose too much, but the approach, we've got also a board of directors yesterday. The approach is, as usual, very deep, serious, and we will come up with some more clue in the future days. I guess I can't say more for the moment, but of course the approach is serious, is systematic, and we are studying in depth how the UK and EU regulation will be applied.
Okay, I understand that this needs to be sufficient, and I won't ask anymore. Thank you very much, Paola. And let me now direct towards Alessandro Guaiana. Alessandro is the officer of the sanction compliance, the European Investment Bank. He's an Italian citizen, and I will switch again to Italian Grazie al dottor Alessandro Guaiana per essere qui presente. Lui ci offre l'operatività e lo sguardo della European Investment Bank, che voi sapete essere il braccio finanziario ed operativo delle istituzioni euro-unitarie e che ha anche ulteriori diverse articolazioni, perché siamo all'interno di un quadro dove poi ci sono delle sottooperatività, delle sottodivisioni molto articolate che curano tutte quante gli aspetti del credito con qualsivoglia modalità possano essere eseguite secondo la normale best practice. Quindi noi abbiamo una situazione che copre tanti e diversi ambiti. So che Alessandro Guaiana aveva preparato anche delle slide che naturalmente può condividere con noi. Lo ringrazio moltissimo per aver trovato del tempo. Alessandro è collegato dal Lussemburgo, gli cedo senz'altro la parola. Ringrazio ancora Paola e la ascoltiamo con grande piacere nel linguaggio che preferisce. Paola ha parlato in inglese perché lei è metà inglese. Questo adesso
No, mi sa che vi ringrazierò in italiano e poi cambierò l'inglese, perché di solito sono abituato a lavorare in inglese, quindi mi è più familiare questi ambiti.
Prego, grazie mille.
No, innanzitutto vi ringrazio prima di tutto per l'invito, è stato una sorpresa e anche un piacere. Specifico che parlerò a titolo personale, non a titolo della banca, doverosa precisazione. Now I will switch to English and just a quick view on what the European Investment Bank is. It's the largest multilateral lender in the whole world. As you know, our shareholders are the member states of the European Union. We have a lot of projects, as you can see from the slide, going on in all over the world. And the main purpose indeed is for developing in specific project in specific field as environment, energy, and others in the whole world, mainly in the European Union, but also outside the European Union. Indeed, the new package of sanction approved by the European Union, US, and UK have been a challenge also here at the European Investment Bank. I will mainly focus not on the specific provision that were put in place since the 24th of February this year, but I will more focus on the challenges that we're facing here. The first thing, but I think it's a basic one, but still the most important one, when we are dealing with sanction, is reading and understanding the new restrictive measure put in place by all the different sanction authorities. Mainly because if we have to talk to the Italian audience, we are mainly focused on maybe Italian and European laws. But when we are dealing with sanctions, we always have to look at different jurisdictions. So when we would like to assess a specific operation and its compliance to the restrictive measure, we have to consider an US and UK framework, because depending on the characteristic of the operation, maybe all three of these jurisdictions may apply. So facing this huge amount of new restrictive measure, what we have done, definitely first studying, as everyone. Then, as you see, we have a lot of projects around the world, and that was indeed one of the main challenges. So what we have done is to perform, and what we are doing actually, is to perform an assessment on the activities of the European Bank based on our internal compliance policy that I'm assuming Paola, speaking about banks, indeed it was underlining a very good point, because usually in general banks are more cautious and refrain to enter into certain transaction, even if at the end there is not really a prohibition by the legislation, and that's indeed a matter of perception, because if I can open a brief brackets, it's true that the first reaction, it's always to stop. So whenever you see sanction around, you see Russia, even Ukraine, they say, okay, it's Ukraine, so we stop everything, and we are not carrying on our activities. And that's the downside of what was happening during the last weeks. Indeed, is an issue of overcompliance in many times. Then, clearly, once you have understood the rules, the restriction and the prohibition, and you have assessed your operation, then you came to the conclusion. So you map the area at risk, the counterparties, and the operation that at risk. So at the end, if you have any concrete issue, you came up with mitigants and remedies that can be hopefully to have drafted a proper contractual arrangement with your counterparty with proper sanction clauses that may protect you in case of breach of sanction provision. Or maybe you find out that in your organization there is a loophole somewhere, and you have to implement new controls within your organization. So the main challenges, indeed, as I was saying, is the combined possible combined jurisdiction that are applicable to your operations. Plus, also in this situation, we have to think about the Russian countermeasures that have been approved by the Russian Federation, and it really depends. I mean, speaking from my experience, sanction that is going from law firms, consultancy, oil and gas sector, financial now, I have to say that you really have to know your business, because there is no one size fit all solution. Depending on the organization you are dealing with, the solution will be every time different, based also on the risk appetite of that organization. Banks definitely are extremely cautious. Businesses that are used to export goods, items, and dealing with risk countries maybe have definitely more risk appetite in this respect. Other challenges are indeed also the controls that are put in place within the organization, meaning the classical one as regards sanction, so the screening of the counterparties, but clearly this is not anymore sufficient, because as we've seen, there are a lot of sectoral sanctions. They are much more difficult to assess within a large organization as the AB. And then clearly everyone was asking for a feedback, immediate feedback, meaning that even before the new restriction were published in the official Gazette of the European Union, we were asked to provide immediately a risk assessment on EIB operation. And that you can think about, it's clearly you face a lot of pressure, but at the end, you just really need to brief and to perform your assessment. Now, I prepared briefly some example of how difficult is these days for advisor to provide you with a yes or no answer, because it was so fast, the drafting of the new restrictions, speaking only, taking an example from the EU regulation, that it's really difficult to assess and to perform an assessment of a specific operation. Here, I took maybe the most interesting example to me now is that one related to the restriction, the export control and trade restriction placed by the European Union towards the Donetsk and Lugansk Oblast of Ukraine, whereby we face this new definition of specified territories that aims at identifying these two regions. But as you can read now, can read on the first line, they are identified as non-government controlled areas. And that's very challenging because as you think about it means that at the moment of the transaction, from a compliance perspective, you should verify if that area is controlled or not by the Russians. That is almost, I would say, impossible. So the tendency here, according to the risk appetite, will be to say yes or no. It's a green light or a red light depending on your risk appetite, because I think nowadays it's impossible to verify if there is a Russian soldier next to the premises of the company that you are transacting with. Also, in an organization where primarily we are financing projects around the world, is where our funds are going, because sanctions are targeting also with financing indirectly certain activities or certain companies. But in an organization like this, think about when we are faced before to assess restriction as those one of importation of specific goods from specific region. What products we are financing, because we have no view most of the time, because our projects are implemented by third parties. So this is just to give you a flavor of what are the challenges that from a compliance perspective companies are facing nowadays. But I sympathize with Paola when she was saying, indeed, it's a matter of perception. Sometimes we are the tendency to say, okay, this is the world is ending now, and we cannot do business anymore. But it's most of the time it's not like this, but it's a matter to have a good compliance program in relation to sanction export control in place within the organizations, and to assess to the extent possible the activity of the companies you are in. So thank you. That was my intervention, and thank you for your time.
Grazie mille Alessandro, grazie per la condivisione delle slide. E adesso andiamo alla nostra accoppiata di Jessica Martini e Sophie Cocard. Se Jessica e Sophie possono, if you can switch on your microphone and your cameras. Okay, Jessica, here it is, we see you. And I hope that with Sophie Cocard will be the same shortly. Just a quick introduction. We have two, now Jessica and Sophie are two experienced lawyers in the sanction and compliance sector. They have been both working worldwide. Jessica has been previously in the luxury sector, and then he switched towards the financial sector, working for Citibank, Commonwealth Bank of Australia, and lately UBS. She had also experience in the pharmaceutical import and export sector, and since the beginning she has been practicing in the sector of sanction and export control regulation across different industries. Sophie Sophie Cocard is an experienced practitioner as well in the sanction fields, and he has been working within US and non-US jurisdiction, especially in Asia. She has been working with the Citibank, JP Morgan, and Commonwealth Bank of Australia, and she has been in charge of infrastructure program and global risk for global banks. So they will share their presentation. I want to thank them because I know that they are connected from a different part of the world. Jessica informed me that despite being half Italian and half American, normally living in New York, now she's connected from some part of East Asia. And thank you very much for aligning to our time. And I don't know where is Sophie Cocard, but I would like to see her if she can turn on the camera because I cannot see her. But I will leave the stage to the two of you. Grazie ancora. Grazie Jessica per la tua disponibilità. Merci Sophie. E buona discussione, prego.
Grazie, innanzitutto volevo ringraziarvi tutti per l'invito, e noi parleremo in inglese, we'll speak in English, it's our sanctions language. However, we wanted to thank you. It's an honor to be here and it's a pleasure. Both Sophie and I find ourselves in Southeast Asia in different countries. And this is really an exciting time and an exciting opportunity to be with you. So having heard, we intended to sort of run through this presentation, and I think we will do that very high level, but sort of having heard a lot of the discussion, it's probable that, a lot of what we're going to talk about will be familiar to most people. So we're kind of going to speed with a little bit more speed in the beginning and maybe focus in on what a sanctions program looks like, without necessarily focusing in, at least not immediately, on what is happening today. Depending on sort of the amount of involvement that the audience might have, we thought it might be useful just to sort of take a step back. I just want to preface our comments by saying that neither Sophie or I will be providing any sort of legal advice, and also that we are not going to be talking specifically with respect to our institutions that we might know have worked for or work for today. That may go without saying, but just wanted to highlight that. And also our comments are going to be very general. So we hope that they're helpful, but they will be quite general and high level. And maybe we can get into some of it in the question and answer after. So firstly, we will be talking about sort of sanctions and what the objectives of sanctions are, very high level. I think we all know that the use of sanctions to exact foreign policy and security objectives of countries has increased exponentially in the last decade. And the prominence of the United States dollar in cross-border trade renders financial sanctions appealing for this purpose, as we're seeing today. And currently, there are close to 40 programs managed by OFAC, the U.S. Treasury Office of Foreign Assets Control. I will say that most of our comments will be focused on U.S. law. However, we're obviously very cognizant, well aware of the very robust programs that there exist all over the world. Sanctions programs in a typical environment, which we are not in today, can take a lot of different forms. There's a lot of tools in the toolkit, starting with listing programs, designations, targeting programs, moving on to sectoral sanctions that focus on specific industries, and they're not full blocking programs. And then, of course, secondary sanctions, trying to thwart the behavior of third country actors. And of course, then export controls and, moving all the way up to comprehensive sanctions programs and embargoes. And typically these are implemented at pace But of course, what we're seeing today is not an implementation at pace. We're seeing the rapid expansion of these programs, and they're moving quickly, and various, there's sort of a menu of these options that are rolled out at the same time, making it very challenging, as everybody has been discussing today. I mean, there are very specific concerns that were articulated today, but even as a general matter, it is very difficult for everyone to keep up with the rapid pace of these sanctions. And in particular, also the nuances between. Go ahead, Sophie, were you gonna go right ahead?
No, I think first of all, sorry, I joined on top of the hour. I have to say I had technical issue. I'm just glad to be here and to be presenting to all of you. Yeah, what I wanted to add as a brief comment to that is sanctions has evolved tremendously over the year, and we have highlighted on the slide, and I think it's a very important point, is that it is becoming increasingly more complex. There is more and more expectation that is coming from our regulators, more scrutiny, and we are expected to also to promptly and to adapt to those changes, right, and be able to respond to the requirements that are being issued. And we are seeing that coming not just from the US, particularly with Russia. You've seen the EU and the UK that are responding as well, very actively and aggressively, and across the world. And if it is important to have, and we cover that later, a very robust sanctions program in place to be able to comply and to have that capability to respond to all these expectations and changes that are coming. Sorry, Jess, back to you.
Thanks, Sophie. Like, excellent points. I think, why don't we go ahead and move to I think a couple slides ahead. I don't have control of the materials, but maybe 2 more slides. We thought it might be, yeah, the next one. Thank you. We thought it might be useful just to talk a little bit about what risk management frameworks mean for multinational institutions, and what is expected, how to respond to what is happening now, but in general, even before. We in the United States, US multinationals, as well as other multinationals, have leveraged and have relied a lot on publications by OFAC. OFAC has been extremely prolific in setting its expectations through publications. So, for example, in 2009, OFAC published a document setting the framework for OFAC compliance, which describes several essential elements. For example, there needs to be an articulated management commitment to a program, meaning a tone from the top, as well as a well-resourced program. Wholesome, holistic risk assessment activities, internal controls, documented policies and procedures that are continuously evaluated, testing and audit that is independent of the control function, and then, of course, robust training programs. And then, in addition to the framework, industry-specific and activity-specific guidance is routinely published by OFAC and maintained on its website. So on OFAC's website, one can find industry-specific guidance relating to the securities industry, related to insurance industry, import and export, and of course, risks associated with operating in the shipping and maritime area. And most recently, OFAC issued some guidance on cryptocurrencies. So there is really a wealth of information out there that sheds light on the regulatory expectation in the United States. And we realize that there is a wealth of information, of course, in other jurisdictions as well. But in terms of framing what a compliance program can look like and should look like, we find these tools to be very useful. And then there's enforcement guidelines. So OFAC's enforcement guidelines are actually part of the regulations. And within them, they explain what are mitigating and aggravating factors. And one of the main aggravating factors is the lack of a compliance program, which makes it really imperative that a multinational institution implement a program. And in addition, through enforcement actions, we find OFAC articulates very specific guidance on controls. A lot of the time we will see enforcement actions that is specific to financial services industry actors, but also non, that talk about screening expectations, and where there are failures, what is expected vis-a-vis remediation. There's a lot of discourse around due diligence of customers, reliance on representations, and all sorts of information that's available. So, we think that those are really good tools for anyone who is, looking at building a program from scratch, or looking at of making one's program more robust. So I think at this point, I'll turn it to Sophie.
And to that, sorry, to go back to that slide, for sanctions program is not the guidance is great, right? It talks about processes, it talks about training, etc. But it takes also an infrastructure, right? You need an infrastructure that is designed to be able to support that compliance program, that detection, right? Those prevention, in order to put in place those processes, in order to have control. Because at the end of the day, it is driven out of people, right? People will build that program, will design it, and the infrastructure, the technology will be there, that part is there, and then you will have also the processes and control that comes in, the documentation, right, which is your policy and standard that will drive, that will support, that will dictate, if you will, the requirements that are required to follow and to comply, so that there's no violation of law, if you will, if you follow what has been put in place. So it is a combination, right? It is not just people, it is also technology that comes in. And of course, the third party, when you have auditors that will come and test that framework and make sure that it is robust and it's working as expected and efficiently. I think we're on the core sanctions processes and activity slide. So this slide is, yeah, thank you. This slide is to talk about exactly what we just referred before, is part of the compliance framework comes with a number of processes and activities, and of course control, starting with your policies, right? You need to build very strong policies and standards and procedures and guidelines that will assist not just what we call the business, but also the compliance into creating this risk management framework to monitor, to manage the requirements that are being set through the laws and regulations. Of course, it will require also a risk appetite. Each bank's work from that perspective may differ from one bank to another, particularly if you take an international bank versus a local bank, you will find the risk appetite may be different, right, when it comes down to certain internal decision. Those policies will help define how each team is going to function at all levels, and it will support that, and it will be managed and maintained through the compliance framework. There will be, of course, rigorous protocol as we put in. So in order to manage those regulatory changes, which are becoming more frequent, certainly with Russia right now, it's more of a crisis mode. You need to have strong procedures in place. You need to have a process to be able to manage it, to communicate it, etc. And most importantly, to take appropriate action, right? It's not just be able to comply, in a sense, apply the law once I understand the expectation, is also what happened once you identify sanction target, what happened when you have what we call secondary sanction or some related parties, etc. So all these actions related to sanctions identification will require or also need to be put in place, particularly reporting. The ongoing review, so that's also important because the framework needs to evolve. It needs to evolve with the sanctions, right? With the demand, with the requirements. So it is a constant change. Your infrastructure, however, you can build the base of that infrastructure, but you will evolve. Your filter will have to constantly evolve with this efficiency and efficacy. You will have to evolve with monitoring control, with testing, with the way you monitor all these processes, the way you report them, the way you're able to identify them. So it is a constant, I would say, it is a constant effort, right, for all the banks in order to manage that kind of demand that we get, as I said. There are annual reviews, sanctions risk review that we call the enterprise-wide risk assessment. These ones are usually applied by most banks, I would say, such an international bank, local banks as well in most cases. And these ones are very useful, particularly for regulator or for external internal auditor to review as well internally from a compliance and business standpoint, the risk factor associated with the business, right, that we have. It gives us a good sense of how each business is processing, what the risk rating is across multiple pillars, because when you do this assessment, you have to test multiple factors, right? Their location, their products, what they offer, their geographies, type of customer, portfolio, etc. So all of that is annual because it is a very large, significant effort. But this effort is required to understand your risk category, if you will, across the bank and be able to take appropriate action as well. The training is ongoing. Needless to say that training is also a function that in itself is critical. It's critical to all team within the bank. We can talk about the business, we can talk about the compliance team, etc. The training ensure that everyone is kept abreast of regulatory change, of processes change, of expectation, right, in terms of control, etc. When the bank change documents that are global in nature, that will trigger some training. It ensures that every user is appropriately trained in order to perform their function and to their maximal capacity in terms of delivering what the procedure require. The filter, of course, is very, very important. I could not stress that enough. The filters are tested on an ongoing basis, but also by regulators. The OCC certainly for US Bank will test the filter and its efficacy and make sure that it is working as expected in terms of the output, the setting, the parameters, the tuning, etc. Filters can be built internally or can be external. It all depends, right? How each bank decide to develop their own framework and how comfortable they are. In all instances, that filter is well monitored, well managed. You will have a dedicated team to support all function across that filter. List management is also important. The banks use lists, right, in order to include all sanctions targets into their filter, right? So sanctions targets are usually what we call individuals, entities, vessels, aircraft, locations, etc. So the list management, if you will, function allow the appropriate management and monitoring governance over that particular function to ensure that the list remain current, that they are updated on time, that they are complete, accurate, etc. When banks have a very large footprint, which means they operate in multiple jurisdictions, they have to, of course, comply with all applicable laws, sanctions laws and regulation across all jurisdictions, which mean multiple lists. Those lists need to have a process in terms of management across so that the filter, as I said, is always up to date and detection can happen. There is what we call a capability to support the efficacy and efficiency of the filter. Otherwise, the filter would trigger numerous alerts. It's important that the filter itself remain efficient without not triggering the right, what we call the good quality alerts. It is a balance, right, that needs to be assessed, defined, and needs to be tested and tuned at all time. This is where the regulator come in and test it. You use an external party to test it, and you test it internally as well. I think if you get too many what we call low quality alerts, your user will lose the ability to deal with the good quality and the ability to escalate within reasonable time frame, particularly if you have a positive match. The due diligence is as important. Screening is a very important piece into the risk management framework in terms of detection, but due diligence itself as a process is also extremely key. Due diligence allow for multiple products, for the customer, for trade, even for securities, when the bank has, you know, asset managers or etc. The due diligence allow an appropriate assessment in terms of AML, in terms of sanction, if there are any risk associated with that relationship. It is conducted, and of course, it's in accordance to procedure, but it will result with what we call risk profile. It may require escalation, it may require decision to either proceed or not proceed, but of course, that could be based on a simple, it's a sanctions target, not proceed. There is a nexus, there is a sanctions concern. It's based on risk appetite and assessment. BAU processes will continue throughout, of course, the period. And that BAU processes that we refer to at the bottom are the list changes, the program changes, and new program. As I was saying, the sanctions programs, the sanctions expectations have evolved. They're becoming more and more aggressive. The turnaround time, and again, we can refer to Russia, and we can cover that more later, are more, I would say, volatile. The banks are expected to adapt and to be able to make sure their business are ready, some level of preparedness, and are able to react and to take appropriate action, right? So that there's no failure in compliance, right, with those laws as and when they are issued. Jesse, if you want to add anything, otherwise we can maybe move on to the next slide.
Yeah, thanks, Sophie. I mean, I think the one thing that we might want to sort of lay out in terms of a framework, there is a clear delineation of roles and responsibilities among the three lines of defense, right? So I think you really touched on that when you were talking about auditing, for example. So audit is considered the third line of defense. And the first line is the business, and they have the primary responsibility. And then the execution, if you will, of the compliance controls. Then compliance is the second line of defense, essentially sets the policies. So there's a real close interplay between the three lines of defense at financial institutions and clearly delineated and systematic controls, as Sophie mentioned and spoke of. I think in the interest of time, we might want to touch a little bit on risk-based considerations. So that's a few slides before, slide number 7, and then jump ahead to the last slide that speaks specifically to the Russia sanctions programs. I think a lot of folks touched on de-risking, touched on risk management, risk decisions, risk appetite decisions. Even in establishing a new program, it is really good, it is wise to take stock of areas where risk considerations, risk appetite decisions need to be made. There is no one, as everybody knows, I think already, there is no one size fits all solution. There are real considerations that need to be taken into account. So for example, some of what we're seeing right now, it is important to determine, based on an institution's footprint, global footprint, and business operations, products and services, what sanctions apply at any given moment, and building controls around those decisions. So there should be some definition, some time dedicated to defining what sanction targets means, who is sanctioned, and then what's prohibited. And as Sophie was mentioning earlier, once there is a detection of risk, what is the process for dispositioning, for assessing and dispositioning that risk, right? That will vary considerably. There's also this, I think, desire and maybe need, I would say, for maybe more aptly, to establish a high watermark, the highest common denominator, because it's very impractical and really impracticable to have a lot of difference across a multinational institution. And so we find, and I think Paola touched on this earlier, a lot of institutions are just, black and white, because that's all that can be managed right now in many institutions. In designing, though, a highest common denominator approach that allows, let's say, for non-performance of services or de-risking of a particular client, there needs to be consideration, of course, for conflicts of law and conflicts of policy. And it's important, and what you'll find in a lot of the multinational institutions is there's a clearly delineated, documented process for resolving these conflicts, with escalation of them as at the center. So additionally, and I think Paola also touched on this, particularly in the financial services sector, you will find that yes, banks are not able to share information. It's not possible to be fully transparent for reasons that I think everybody can well understand. But just to articulate maybe a little bit, to touch on the interplay between anti-money laundering and sanctions, there is really steep enforcement for financial institutions that enable, even if inadvertently, their clients to evade sanctions regulations. So in sharing information, it is putting the institution at risk that there could be sanctions evasions, that a transaction could be quote unquote stripped of information and then could avoid detection. So you'll find that multinational banks will have very well established protocols for what can be communicated to clients and what cannot, and when there needs to be escalation as well for clients that may be escalating. And then finally, as we're seeing today, and we can now maybe pass to the very final slide on the Russian sanctions. What we're seeing today is that there are a lot of de-risking decisions being made, not just by financial institutions, but by a lot of different companies that are exiting the Russian market, that are potentially not processing transactions, not offering specific services. And I think, we'll have to wade through all of those issues as they come up. When implementing a program of this magnitude, I think most big institutions would like to think that their control environment that Sophie described in detail is able to absorb change in a way that's sound, and by and large that is true. But I think what everybody is talking about and experiencing here is that there's really a tidal wave of change, and everybody is struggling. Everybody is struggling to find the right approach, to find the right answer. And it's safe to say that preparedness in this space is critical. So the sanctions compliance framework, the risk framework that we touched on and that we discussed earlier, how is that triggered here? Just normally through constant monitoring of developments, and really a lot of regulatory engagement. Some institutions, as a risk appetite decision or as a policy decision, will engage with regulators routinely, will ask very specific questions with the assistance of their legal team. Of course, not everybody at an institution can reach out to the regulator. It's usually handled through a regulatory team, a very senior level regulatory team, and asking specific questions and asking for guidance when facing ambiguity. That kind of dialogue is critical to the success of sanctions compliance programs. I think it's safe to say that both companies and regulators find that kind of dialogue very beneficial. And it helps actually refine and clarify the sanctions tool significantly. So it's really important. And if one is working in an institution that cannot afford that kind of open dialogue for whatever reason, maybe it's not staffed that way, it's really a good idea to engage with your outside counsel through your legal department if you have one, to talk to consultants. It's always a possibility to reach out to regulators on a known, usually a possibility anyway, on a no names basis and in a sound way. So for me, I cannot, this is my own personal, observation, but I cannot impress enough the importance of engaging with regulators in this space, and particularly now where there is such complexity. And then really being prepared for a fast response. I mean, nobody can predict the future, but I think with these sanctions, even though nobody could have predicted the rapid pace with which they arrived and how complex they are and multifaceted, we probably, most of the industries out there had a sense of what was coming and could at least prepare high level with understanding the risk within an organization so that there could be a rapid response. I don't think everybody could predict, but certainly some could. So preparing and responding is really important. And then Sophie spoke at this already, but updating screening engines and testing and tuning them appropriately to maximize efficiency is critical. And lastly, I would say communicating. The communications have to be constant at a time of crisis with any sort of crisis management response, but particularly here with far-flung institutions. I think a lot of institutions are speaking constantly with their businesses with the first line and organizing some centralized fora for questions to be raised and answered so that there's consistency across the world. And what's going to happen, nobody knows. We think there may be a more comprehensive sanctions program coming. There may not be. There may be more of this. I think we can be ready for there to be a pretty bumpy ride ahead. And so with all that said, we thank you for this opportunity and we look forward to working with everybody, in the ongoing months, years, who knows.
Thank you, Sophie and Jessica. Thank you for, you said it would have been high level, but I think that you have gone in depth into critical issues, and I have two questions for you. The first question is that from your presentation, it appears to be extremely clear that especially banking institution, but not only banking institution, should have in place the necessary critical structure in order to process the application of sanctions. So you need to have people that is properly trained, with proper program, with proper knowledge, and with a formal procedure in place in the entity, not when the sanctions are out, but at all time, because managing sanction is a permanent issue. You said in your presentation that the immensity of the designation, so the designated people are so many sanctions are in the market that you always need to screen the market to understand who is sanctioned about and to conduct on a rolling basis due diligence on those people, on those entities, on those businesses. So this is the first point that comes out, and I have two questions. The first is how normally in your experience how normally was organized the group as a matter of practicalities, what were the organization base and you know, the number of the people, the knowledge of the people, the program to train the people. That is important to understand also how to react. The second key question to me is that you said before that there are a lot of intersection between the sanction issue and the anti-money laundering legislation. In the anti-money laundering, the legislation is key, is critical, is fundamental to apply properly the tests about the ultimate beneficial ownership. And this starts to be, despite what you read in the Octo regulation or in the international guidelines or in the manuals, it is always very complicated because the test of the 20% of shareholding, it appears to be sufficient, but sometimes it is so granular and so divided, the shareholding of a company, and normally it is done on purpose throughout fiduciary companies, trust companies, or just you know, companies that basically are not transparent, that to conduct a proper diagnosis of the application of the beneficial ownership might take time. So this is the first issue. It takes time, so I might be late in either freezing an asset or revoking an authorization or taking the proper conduct. And how do you deal with that? Because then it comes to the responsibility of the organization. No one wants to be late. No one wants to be in a difficult position. But however, the ultimate beneficial ownership is not an easy game.
No, Sophie, why don't I take the last question first, and then maybe you want to take the second question. How does that work?
Sure.
Yeah, so
No, go ahead.
you really hit the nail on the head with beneficial ownership. It is an immensely complex analysis, and I think we're seeing an evolution of the regulatory expectation every single day, including with the most recent publications. I believe it was in the UK, of, you know, aggregation of ownership, right? And differences between just counting the ownership and then you know, without there being like a clear understanding of control between, you know, between those levels of ownership. So I think it's I don't want to say fluid, but it can feel very fluid in terms of what the standard is. And I would say that, again, without speaking specifically about any institution that I've worked for, or any, you know, or with, I would say, it's important to use that question as an opportunity to decide where the line should be drawn. For each institution, it will differ. I would say that, you know, there's been an evolution over many years of this, because the tools out there and the information that's available about ownership is different. You know, there are watch lists out there that one can subscribe to. There are, you know, there's research, immense amount of information, sometimes unreliable information in the public domain. So one has to make determinations about which types of this information is reliable, and those are internal policy decisions. With that being said, I would say there's two other avenues for seeking clarity that I think are really critically talking to participating in industry groups, right? So depending on which industry you're in, figuring out among industry in an obviously you know, competitive way, without compromising the competition, what is, you know, what is everybody else doing? Because that's going to set the standard around reasonable care. And then in addition, when faced with a very specific question, engaging with the regulator and asking the regulator, providing all of the information, you know, as Paola said, to your counsel, seeking a legal opinion, and then having, in whatever way, having that information go to the regulator. The regulator may not know either. So ultimately, it may come down to a policy decision. And then in terms of the timing, I would say that while one is performing an investigation and has not concluded yet, has not concluded one way or another, blocking is not required, at least under US law. I mean, this again is not legal advice, but there is, while there is haste needed, I think the haste that we see right now isn't entirely driven by the regulatory expectation. It's also driven by the desire that a lot of folks have out there to do the right thing, you know. So, but I do think that while investigations are underway, there is reasonably right underway, blocking is not required. And then I will turn it to Sophie to talk more about sort of the sophistication of programs and, you know, the level of expertise and anything else you want to add, Sophie.
Yeah, no, I just wanted to add, because when you were talking about UOBs, right, we talk about ownership, we look at it at customer level, but the same apply with the sanctions target. We've seen that a lot actually coming with the Russia sanction, where there is an expectation to identify, of course, all entities related to the sanction target with a certain ownership or control. And it is a challenging, right? Require an intelligence unit to identify those entities, to decide if they're going to filter or whether it's going to be identified through a specific search. Some local regulators have the same expectation. We've seen that with, for example, Singapore, right, with Russia, with the expectation to find those related entities, or those entities that have some level of control, ownership over the sanctions target, which again is also challenging to do and challenging to find. It's not provided in the list, right? When you get a sanctions target, you get the main names and then you get the AKAs, but you may get in some lists what we call 50% ownership, but the expectation often is a bit larger population. And that's another, I think, work that has to happen, Jess, as well, when we talk about, that was what was coming to
100.
my mind.
Yes.
Yeah, yes, which it is also a function that is very difficult, right? And each bank will have different people doing that search and identifying and making that decision as well. Second question, just to return the question to make sure I didn't lose the ask, is, let me ask you, because otherwise I'm gonna get lost in my answer. Is, was it the question specifically about the type of people required for that framework to succeed, or was it more specific in regards to the infrastructure itself?
I would like to have both information, but let's start with the people, because I have an additional question, because
Right.
there is somebody from the audience asking to me by WhatsApp, when you set up this kind of organization, what are the skills? What are the requirements you want to have? Because you need to have analysts, you need to have lawyers, you need to have different skills
Yes, of
on the
course.
same scenario. And this is important, because to run up such a program, an internal program, to follow properly the policy into the organization, especially when there is such an enormous increase of pressure, you need to have the proper resources in place. And when I mean proper resources, not just okay, the external advice, we are here for that. So the more it comes, the more we are happy, the lawyers. But at the end of the day, lawyers can do just a chunk of the work, because you need to get the fundamental elements, the piece of actual information from the clients.
Yeah, that's correct. Look, each institution will have their own hiring expectation and protocol. When it comes down to compliance sanctions officer, if we are talking about the second line of defense, because first line is the business, or audit, if you will, right, for the third, it does require a very specific skill set, experience and expertise, depending on the level you're applying for. And depending on the institution, they will require specific experience, right? They will look at your years and where you've been working, what you attained, etc. Right, and all of these factors would be looked into and certainly verified during the interview process, which can be, depending on the position, quite multiple and lengthy. So it is a very specific skill set. It is experience and expertise that you build over the years with the exposure. I think there are multiple roles in that compliance framework, right? And depending on the role, you can learn those roles, right? And move around. Like I said, there is the technical side, which is on infrastructure, but still as important because compliance infrastructure is very specific as well. However technical, but require great knowledge about filter and how it should function, etc. You have I would say it's not necessarily a lawyer, even though we do have there are lawyers are being hired, but understanding the law and regulation, ability to interpret that law, ability to communicate, ability to put together policies and standards, that is also a very specific skill set, right? That the person will need to have, particularly when you stand on a global at group level. That group will be provided for the whole franchise. So it is important to ensure that you've got the right people and the right skill set at each level. And then you have other team, right? Because it depends how it's divided. Training is a function in itself. If you have a big institution, training is key. You need to ensure that the first line, the second line are trained. And I think having a specific team is as important to put together those presentations, to ensure they are being disseminated, to ensure people are taking that training, keeping that training up to date. So training itself, and even though you do not need to have specific training knowledge, but still is as important and will require, I would say, a very specific person to be part of that team. You also have, of course, the team that, and Jessica touched on that deal with the output, the investigation process, the ability to review what we call an alert and understand it and make the right decision, even though there are procedures in place that will assist, and some are rules based, some are more investigation like, more, I wouldn't say subjective, but require more knowledge and understanding of what you're looking at, what you need to look for, right? And it does require training. Some people, you have employees that learn through the process. They start at more towards the bottom of the team and build their skill set, but it's still a skill set that requires an eye for detail, an ability to be inquisitive, detective-like, if you will, right? To be able to really investigate and make the right decision to either escalate, particularly if you are the final decision, right? Just if you are compliance and you are the final decision maker at that point.
And maybe we want to touch also, because you mentioned some of your questions were about the interplay between AML compliance and sanctions. And what we see a lot with the prudential regulators, the banking regulators, particularly for institutions that are viewed to have compliance programs that need a little bit of work, that the prudential regulators can actually be fairly prescriptive about the skill set that employees that are operating in the compliance space or in the business or in audit should have. So while from a sanctions, like an OFAC perspective, that is not something that they regulate. They are not a regulator, they're an enforcement authority, but the prudential regulators may care and may impose standards and require specific types of training. So there's, robust training programs that are built, as Sophie was saying, designed to get people up to that level. But I think by and large, like, nobody is born a sanctions person. You really grow into it, and you need to have that special sort of, as Sophie was saying, inquisitiveness and the ability to discern risk and also to follow procedures. As you will see, as I'm sure you've heard from us, in a bank, it's very prescriptive, right? Who does what when? And there needs to be escalation. And it's imperative that people not overstep their remit. You do not want everybody in a bank interpreting a general license, for example, or interpreting an FAQ, because you're going to have, really broadly ranging and unmanageable exposure there. So, yeah.
Yeah, that's right.
Thank you very much, Jessica and Sophie. I have a further question, but I promise I would have taken less than 1 hour. Now we have turned to 1 hour and a half, but it is a great success. Thank you. I have several comments from the audience on my WhatsApp and email. And everybody would like to intervene, but this is not, let's say, our rolling debate session. We have to stop here, but considering your extraordinary availability and your capacity to deliver the content, we might go back later on to this issue and discussion, because there is the entire world is experiencing unexperienced problems. So we want to understand better what will be the outcome in the next future, and especially how different jurisdictions will face those issues. You have made a reference in your slide about all the vessels that have been taken by the authorities. And this is a great issue, for example, in this country. In Italy, as you might know, we have a large part of the Russian vessels that normally stands out in the winter time around Liguria and Toscana. In summertime, they are in Sardinia and Sicily. And we have been seeing police operation entering to the boat, arresting the boat for 24 hours and then releasing the boat because they were not capable of understanding who was the ultimate legitimate owner of the boat, because there was a kind of interesting article on the newspaper about all the Chinese boxes that were controlling this giant boat in the port of Livorno. And this is a practical issue that somehow takes some interest, some general interest. And then what happens if your boat is arrested and then it is discovered that maybe just as a matter of interference between your company and the name of a company that is listed somewhere, your boat is arrested. This is another case that has happened, because there is also this risk of to make disambiguation between similar words, similar names of the company. And once you are designated and your company is Polaris, then all the Polaris company, they suddenly become a company at risk of arrest of assets. So this is another practical example of things that are actually happening in the reality. So thank you very much. Now we come to an end. I want to thank again Paola for this brilliant introduction. Paola, as we said, today was having different hats, board members, general counsel of a company that is experiencing a lot of turbulence in the air right now. Thank you again from the European Investment Bank that I know he had left because he had to join a meeting. And thank a lot for this magic couple of very competent girls that presented in a brilliant manner, very intriguing and interesting presentation, and really a big array of information. So we would like to go back to the subject sooner or later. I hope sooner, as you said before, Jessica, sooner or later we will work together, that's for sure. Maybe better sooner than later. Thank you again, Sophie. Thank you again, Jessica. Thanks to everybody.
Thank you.
And a special final thanks to Emanuele that was organizing and liaising with all the panelists to set up this webinar. It has been very interesting. Have a good day. Thank you. Bye-bye.
Thank
You
you.
too.
Ciao,
Thank you so
grazie.
much.
Grazie.
Arrivederci.
Arrivederci, ciao.